This is attorney Eric Bolves. This is a shortened version of a 7-hour seminar that I did to help train other attorneys on how to file bankruptcy. I hope you'll find it interesting.
The nuts and the bolts of Chapter 7 and Chapter 13. Section 2, Chapter 7. Now, getting back to the basics again. Bankruptcy is relief from debt. That's the whole purpose of it under our system. The bankruptcy code that we have helps the debtors administer their debt or take care of their debt. And it has to be fair to the creditors too, but the focus is really relief for debtors. We have the automatic stay, the protection in the court. Let's see here, that's correct, yeah, protection from the court, and the resolution of it is a distribution to creditors of non-exempt assets and the discharge. Okay, under the rules, under uscourts.gov, you can find that a Chapter 7 entitled Liquidation contemplates the orderly court-supervised procedure by which a trustee takes over the assets of the debtor and reduces them to cash and makes distributions to the creditors subject to the debtor's right to retain certain exempt property and the rights of secured creditors. So the idea here is that if you're filing a 7, you're saying, here it is, trustee, except for this stuff. And you have to specifically enumerate what stuff you claim you have a protection on. Because if you don't, the trustee can go get it. I have seen cases, and I call these expensive, cheap bankruptcies, where a person will go in pro se, or they'll go in having their forms filled out by a paralegal who is just a form filler. You know, paralegals, at least in the state of Florida, aren't even supposed to tell you what goes on what line, because that would be providing advice. So sometimes, in fact, I have seen this where people would go in and they have all this property, and they assumed because their brother in Michigan told them that that was exempt, that there would be no problem. And they lost stuff. I've even seen people lose houses because of it, because they didn't want to spend the money to hire an attorney, and because of it, it became very expensive. Now, probably in most of these cases, they later went out and hired an attorney, filed an amendment very quickly, and got it fixed. I'm hoping that's the case. But the idea here is that a 7 is a liquidation of debts and assets. And unless you have your protections in place for the assets and the property that you want to protect for your client, the trustee will liquidate it. And that's the idea of a Chapter 7. Okay, what happens at the creditors meeting? And like I said, it should be called the trustees meeting. There is it's a time when the bankruptcy trustee can ask questions. The first thing that happens is you go in and your client is sworn in. Do you solemnly swear that your information will be true and correct to the best of your knowledge? Swear or affirm is the way that they do it. And let's see, that's 34, trustees checklist. Let me scoot forward here. And a lot of times what the trustee will do is ask the individual to fill out an additional form. I have it, one of the forms here under number 34. The first thing they do is they do swear you in. And the reason for that is that there has to be a verification that there was an actual person who filed the petition, that they ask for a copy of a photo ID, a proper ID. Some trustees will not accept, they're not supposed to accept expired IDs, and proof of Social Security. That can be the Social Security card, that can be a W-2, that can be something from another government agency, or something that's not created by the debtor. Okay, so the debtor's own tax refunds won't do it. They will ask if all of the creditors are listed, all of the assets are listed, and then they'll get into some of the specifics about the information that is on the petition. Where did you get the value of that car? How many miles does it have on it? They require that you put the VIN number down because a trustee can look up and find out anything they need to know about a vehicle by the VIN number. It's at time that they will ask about the exemptions. Sometimes the trustee will ask, okay, well, Mr. Bolves, why did you claim this exemption on this piece of property? So a lot of stuff gets done. They really should call it the trustees meeting because it's the trustees' opportunity, really the only opportunity to meet with everybody involved. It is open to the public, and when you go into a creditors meeting, it'll be you, your client, and probably a bunch of other attorneys and a bunch of other clients. And I usually tell people to show up a little bit early so that they can listen to how they go, because it's the same question over and over again, pretty much all day long. All right, so the trustee administers the oath or affirmation, and so a good thing to do would be appendix number 34. Take a look at this, and in fact, this is good to know when you're preparing the petition, and we will go into that because some of the questions here you need to know the answers already. Are they personally familiar with the contents of the bankruptcy petition? Did they read the petition before the case was filed? Did they read all 60 pages of the petition before the case was filed? That is a question. Did they read the worksheet that describes the kinds of bankruptcies that there are available? Have you ever filed bankruptcy before? Because you can't file bankruptcies without limit. There's some timing involved if you have to file more than one. Are you ordered to pay alimony, maintenance, or child support? And the reason they ask that is because the trustee has a requirement of giving notice to the individual. So if your client is paying child support to his ex-wife, if the trustee collects any money in that case, that is a priority claim. And that's actually the highest priority claim, and the trustee has to pay some money. So that should actually be in there in the petition. Let's see here. What's another good one? Tax refunds. That's a big one. If at the time of year that the case is filed, your client is owed a tax refund by the IRS, that refund most of the time is going to be the property of the bankruptcy estate. The only exemption to that would be if most of the refund is for earned income child tax credits. And there's a very specific part of the tax return that you have to look at for that. We're not just talking the normal deductions that you get for having kids. It's lower on the page where it's actually money that your client gets from the government because they have the children, not as a refund of any taxes that they have paid. So the trustee can't have that amount, but it is most of the time a regular old refund is something that the bankruptcy trustee can get, and that's either in a Chapter 7 or a Chapter 13. And let's see here. Are there any changes or amendments that need to be made before they get started? Have you sold, traded, or given away any property in the last 2 years, including any foreclosed property or repossessed items? And the reason for that is the trustee is looking for transfers, something that might be voidable. We'll be talking about the powers of the trustee. They really can do a lot. What I tell clients is that the trustee can undo just about anything you have done in the last 2 years under the right circumstances, or for their case, under the wrong circumstances. So I need to know, what transfers have taken place. Did they sell their car? Did they give something away? Is their name on any other property? How does all that work? Do they have any lawsuits? Whether they're being sued or if they're suing somebody else, because a lawsuit can be an asset. If your client is the plaintiff in a case where they may end up with $200,000, $300,000, that's an asset. That's an asset that the bankruptcy trustee, at least on the pain and suffering section, this varies somewhat from state to state, but the trustee could basically take over the case and settle it and the trustee does not have to settle it for its full value. The trustee can jump into the case, give a call to the attorney who's handling the personal injury case for your client and say, hey, let's settle this thing. Let's finish it up. So yeah, that becomes property of the estate. Have you inherited anything recently? Are there still, for example, if you have a client who their father passed away a year ago, and the probate hasn't quite closed yet, or there might be some inheritances that are still being worked on, like the sale of a property, that's something that the trustee can get and sell to, disperse to creditors. Okay. Also, if there's an inheritance within the 6 months after the case is filed, even after the case is closed, that is still considered part of the bankruptcy estate, and the trustee can get it. All right, the next section that we're going to be dealing with is specifically Chapter 13 cases. We'll be talking about the definition of a 13, what it is, the parties involved, the timelines, how to put together a plan, what a plan really is, and also we'll talk about some motions, additional relief available in the case. And that's becoming more and more. There's a lot more stuff out there these days than there used to be. Okay, the definition. Chapter 13 is a reorganization of debt by which the debtor proposes a plan that pays all priority debt. Okay, must pay priority debt, which, and you can choose which secured creditors will be paid, and pays whatever else is able to be paid to unsecured creditors. So, must pay priority debt, choose which secured creditors they will pay, and pay what they are able to unsecured creditors. The maximum time that we have for a Chapter 13 plan is 60 months. Any longer than that, and we have to go into a Chapter 11 case. All right, so what is the goal of a Chapter 13 plan? All right, it is personal reorganization, obviously. In a plan, when we're putting it together, we have to get caught up with secured creditors, all right, and the debtor has to pay what they can afford to unsecured creditors to protect their assets, if that's an issue, to eliminate second mortgages and other liens. You can sometimes value vehicles, and most of the time it's a 60-month plan. So let's take a couple of these here. Protection of assets. Let's say a person would normally be a Chapter 7 case. Their income is under the means test, not a problem, and but they have a piece of property. Let's say they own a lot on the side of a lake someplace, and they want to keep it, and that lot is worth $10,000. Well, and they don't have $10,000 because as soon as you go in to the creditors meeting on a Chapter 7, the trustee is going to say, well, in exchange for me getting rid of all this other debt, you got this $10,000 unprotected asset. You either need to give it to me so I can sell it and pay money to the creditors, or you need to give me $10,000. Well, if the person doesn't have $10,000 and rich Uncle Fred doesn't want to give them a loan, what they can do is they can file a Chapter 13 and they can keep the property as long as they pay at least $10,000 to their unsecured creditors. That's the trade-off there. So they're going to end up paying $10,000, okay? And in a Chapter 7 situation, they have to pay it all at once. Trustees will give you, in a 7, they will give you an opportunity to make a payment plan, but generally not very long. In our area, 10 to 12 months is the norm. Every once in a great while, I see a trustee allow it to go to 18 months. Sometimes that involves tax refunds, though. I think that's the reason they do it. And even that could be a big payment. So if you're going a 10-month plan on a $10,000 asset with a Chapter 7 trustee, the payments are going to be $1,000 a month. That's just too high. So instead, you may find a person who wants to protect their property by filing a Chapter 13 plan, whereby they can pay this amount over the life of the Chapter 13 plan. Okay, it could be $10,000 divided by 60 months. So that's a little easier to handle rather than divided by 10 months. Generally speaking, in a Chapter 13, you can protect whatever assets you want to as long as you pay the amount of your non-exempt assets through the plan to the trustee. Stripped on a second mortgage. This is now, well, it's been available for a while in a Chapter 13 and is now available in a 7-2, but there's some hesitancy there because there's some still cases on appeal where if they go the wrong way, we may not be able to do that for much longer in a 7. However, in a Chapter 13, the idea is that if you have two mortgages and the first mortgage balance is greater than the value of the house, then the second mortgage has no equity covering it. So really, even though they have a lien, the lien has no value. Because if the house did go to foreclosure, they would get wiped out because there's no equity. So, under the circumstances, what we are allowed to do is file a motion to strip where we prove what the value of the property is, prove that the amount of the first mortgage is greater than the value, and prove that the second mortgage really doesn't have any equity on it, and convince the judge that that second mortgage, or third mortgage, really should be treated as if it were a credit card. So let's put it in the basket with the credit cards and doctor bills and things like that, where they get leftovers, very small amounts. And as long as the debtors take the case all the way to the end and they successfully pay all 60 months, at the end of that 60 months, they get an order which eliminates the second mortgage. It strips it. After which time it's a good idea to record that in the county records. So that's a nice thing that we can do in a Chapter 13. Also, value property. If there's any property that has some collateral, or actually property that is collateral for a secured creditor, such as cars or even rental income properties, and as we were kind of talking earlier, what we can do on this is that let's take the car example again. The car is really worth $10,000 and the lien on it is $20,000. We can value it, get an appraisal, file our motion, prove up that the value is actually $10,000, and then what we do is we pay that $10,000 over the life of the Chapter 13 plan. Okay, I have some clients that were doing that very same thing with an entire house. It's a rental income property, and it's not worth a whole heck of a lot. And we did some calculation. Yes, we figured out how much money they're getting in rent and how much the property was actually worth. And if we do a motion to value and ask the judge that we can pay the value of the house out over the life of the plan, the amount that they're receiving in rent is greater than the amount that the clients will be paying into the plan for that. So for them, it really worked. So, that way, at the end of the 5-year period, that rental income property is going to be paid off free and clear. So that's a pretty good deal. It's like zero interest financing on property. A lot of times you don't see that happening because the value has to be within a range that people can actually afford. Now, if this was $1 million house, that $1 million divided by 60 is still a lot of money, and probably people would probably not be able to do it. Okay, and the plans again have to be at least in a Chapter 13, no greater than 60 months. The creditors meeting at a Chapter 13 is really quite a bit different. because the trustee is not sitting there looking for stuff. The trustee is there to, well, a couple of basic stuff. You've got to administer the oath or affirmation. Ask the same stuff as in a Chapter 7. Ask if the debtors have provided all of the information to the best of their ability. Ask if they have listed all of their creditors and all of their assets. And from that point on, the trustee is looking for information relating to processing the plan. And often what will happen is that the trustee or the trustee's representative will take the opportunity to mention a couple things. They'll say, oh, their calculations were $10 difference, or their liquidity was short, or this should be 100% plan, or basically little tweaks. Sometimes if it's obvious that something should be filed, or an amendment should be filed because something is in the wrong place, or it's more housekeeping. The creditors' meetings in a Chapter 13 are usually a little bit shorter. Now, creditors can show up. Parties in interest can show up and ask questions, but they are much less likely to in a Chapter 13 as they are in a Chapter 7, because Chapter 13s have it's tougher to object to a Chapter 13. And the objections that you do see are simply normally matters of something being listed incorrectly. Like I will get an objection from a mortgage company in a Chapter 13. And that objection usually is, on the petition it said that $95,000 was owed, when in fact $96,132.57 are owed. Okay, that's easy to fix. Or that the payment amount on the plan was $723 when it's actually $801. Okay, well, we can fix that too. It's usually little tweaks, things along those lines. Every once in a while, it's something a little more major, like at least in the state of Florida, credit unions like to cross-collateralize all of their loans. So if you owe a car loan and you also have a personal loan with them, chances are it's all tied up in the same collateral, or a credit card also. And they may object based on the fact that all of their collateral is not included. And then you would have to respond to it. But that's part of the whole process leading up to the confirmation, at which point everything settles down into a plan that the court is going to be able to approve. And again, they call it the creditors meeting, but it should be called the trustees meeting, because it's the trustee who gets the most use out of it.
If you'd like any additional information on bankruptcy, please don't hesitate to give me a call at my office at 407-894-1002 and check out the website, thelegalcenter.com.